All right, today's date is April 14th. We are sitting in Summit County. Glad to have in-person arguments again, so welcome. The panel, as you can see today, is Judge Callahan to my right, Judge Sutton to my left. I'm Judge Tito, so I'll be presiding today. I noticed we have two appellees, so have you discussed how you're going to split your 15 minutes?
We have, Your Honor. I'll take the first 10, and then we'll take the last 5.
All right, great, thank you. As you know, each party, the appellant and the appellees, are going to split, have 15 minutes to present their arguments. If the appellant is going to reserve time, let me know up front, and I'll keep track of that for you. Let you know as you get close.
Yeah, Judge, I'd like to reserve 4 minutes for rebuttal.
4 minutes, okay, I'll let you know as you get closer to that time. The arguments, as you know, are being recorded, so we ask that you keep your voice up and stay at the podium. And while we don't have the situation here, since we are videotaped, I always like to announce that the court has a procedural rule, I suppose, where we don't mention the names of children, minors, or victims during arguments. I can assure you that Judge Callahan, Judge Sutton, and I have read the briefs, and we are prepared to proceed if you are. Counsel, you've got 11 minutes before you get into your rebuttal time.
May it please the court, my name is John Latchney, and I'm here on behalf of Boston Heights and Officer Michael Taylor. I want to start out by making an observation that this court made in December 2021. It's one that courts have made often, regarding willful, wanton, or reckless misconduct. And this court had indicated in Anderson versus Westlake that these are rigorous standards that in most cases, most circumstances, are difficult to establish, particularly when there are police officers involved. And this case is no exception. The trial court denied both the village immunity, apparently finding that there was a genuine issue of material fact as to whether Officer Taylor's conduct was willful or wanton, which is the standard for the liability against the village. And also, there was a genuine issue of material fact whether Officer Taylor's driving was wanton or reckless, which is the standard under 274403A6. So, the one thing that the court focused on, to the exclusion of everything else, was that one of the drivers, who provided an affidavit in this case, Mark Roberts, did not hear a siren. That was the sole fact upon which she indicated, at least in her written opinion, that served as the basis for the denial of summary judgment to both the village and Officer Taylor. I went back to prepare for argument, and I reviewed Mr. Roberts' affidavit. And one of the things that I observed was that he indicates in his affidavit that he had pulled onto the right shoulder of the exit ramp to let the cruiser pass. That suggests to me that he came to a full and complete stop. He also indicates in his affidavit, paragraph 7, that after the cruiser passed him, he was roughly about 280 yards away from the intersection, which is quite some distance. The third thing I noted from his affidavit is when he said, his literal quote in his affidavit is, "I did not hear the police cruiser siren on the exit ramp prior to the accident." And this fact alone, without really further foundation, doesn't create a genuine issue of material fact. And the reason being is there's no evidence in the record to establish what was meant by on the exit ramp. Certainly, if Mr. Roberts had been quite some distance as he stops and the officer passes him and accelerates to 51 miles an hour up the ramp, he's starting from a dead stop. There's no indication that he would have been able to even hear the siren at the top of the intersection, or he was close enough. There's no indication that there were any other factors, such as the radio being on in his car or anything else, that would have prevented him from hearing the siren. So what we have is some, I guess what you would call, ambiguous testimony of a negative nature. In other words, the fact that he didn't hear something doesn't mean that it didn't happen for purposes of this case, because there were other witnesses who were in close proximity to the intersection, namely Nicole Jones, who heard the chirp of the siren. And in fact, plaintiff testified he heard a whoop, some kind of sound prior to becoming involved in the collision.
So did he describe that whoop as the sound of a siren?
I don't think he did not use the word siren. The word literally he used was whoop. I think when we all drive, we've all heard sirens. You know, oftentimes that they're continuous.
Well, we've heard the whoop of
There's
the
a
siren
chirp.
too. That's pretty darn loud.
Yeah.
It's meant to be.
Yeah. And my point is that fact alone should not have precluded summary judgment in favor of Officer Taylor and the village. Because when you look at the totality of the circumstances here, the facts indicate that he did not engage in a perverse disregard of a known risk. The officer was on a call to duty, an emergency call. That's not disputed. There's no dispute that his emergency lights were activated the entire time. There's no dispute that he slowed down as he approached the intersection. And the event data recorder indicates that he slowed from 51 miles an hour down to 20.9 miles an hour within 2 seconds of the intersection. One of the drivers who had stopped, who had seen his lights and sirens, and who had yielded the right-of-way to Officer Taylor, said that she saw the lights flashing and she heard the chirping. And I think one of the main arguments that plaintiff makes, and State Farm makes, is that Officer Taylor accelerated somewhat from a speed of 20.9 miles an hour to 30.6 miles per hour as he, in that last 1 or 2 seconds before the intersection, and that's the basis of their claim that he acted recklessly. But think about what Officer Taylor encountered. He encountered an intersection where the cars had stopped. He saw a van, he allowed the van to pass. Ordinarily, I think it's, you know, we all know that if there's whether it's a fire department vehicle, police vehicle, ambulance, that we're supposed to yield the right of way. And I think police officers are entitled to assume that others are going to follow the law. So, you know, the question becomes, is it a perverse disregard of a known risk for a police officer with lights activated to enter an intersection and assume that others will follow the law by yielding the right of way?
Does it make a difference as to whether or not the light facing him is red or green? Wouldn't he have a heightened duty if it was red?
Obviously, he has a duty to proceed cautiously or slowly through the intersection. He doesn't have an obligation under 4511.03 to stop because there's an exception for both firefighter vehicles and police vehicles under the statute. But I would suggest to you that entering the intersection at a speed of 20.9 miles an hour, which is even below what you would have in a school zone, is a relatively cautious and safe speed. I think, you know, one of the things that probably generated this lawsuit was the state highway patrol officer's indication in the police report that our officer was doing 60 miles an hour. As he later learned, that was anecdotal data because the GPS satellite had failed to function, and it didn't capture the data as Officer Taylor was driving his police cruiser up the ramp. So even the officer had to admit that that information that he originally put in his police report was wrong. And he had to concede that the event data recorder in the car, the black box, had the correct information.
Counsel,
Yes?
I want to go back to something you said in the very beginning, and I apologize, but I needed to go back and check my notes and internally scratch my head a bit here.
Okay.
You said that the trial court denied both immunities because we know the village and then the officer are both being sued. But as I read the trial court's decision and then read it again, the terms I see, and the court applied it to the officer, used willful and wanton. And I'm struggling a bit because that's the standard for the political subdivision.
Correct.
But that's not the standard for the police officer. We have malicious purpose, and I don't think anybody's arguing malicious purpose here, but you have wanton and reckless. I mean, did the trial court really address both immunities here?
It seems as if the trial court focused solely on recklessness because, as we know, wanton misconduct, which was not the focus of the court's decision, requires the failure to exercise any care whatsoever. And clearly this record shows that the officer exercised some care. He slowed down, he had his lights set, etc. So I think what we're really talking about is not whether the village is liable, but rather whether Officer Taylor engaged in reckless conduct such that it would deprive him of immunity under 27.403A6. And I believe that when you look at all the circumstances of this case, the question is did the officer perversely disregard a known risk?
Counsel,
Yes.
can you speak to the issue of the written reprimand that the officer received and the impact of that, if any?
I can actually.
You can, but you're going to be into your rebuttal.
Oh.
Just so you know.
Okay, well, that's okay, I'll continue. Whatever I have left, I have left. All right. One of the things the courts have said about departmental policy violations, it's been in Argervite versus Neer, O'Toole versus Dennehan, it's the third paragraph 3 of the syllabus, is that evidence of a policy violation demonstrates negligence at best unless there's evidence that the actor has knowledge that his conduct will in all likelihood result in injury. So it may be evidence of negligence, but not necessarily evidence of reckless misconduct.
Thank you.
I'm going to say the rest of my time.
All right, you can see you'll have 3 minutes and 17 seconds. Thank you for that argument. So I'm going to start the clock at 15. Whenever you stop, co-counsel will have the balance. How's that sound?
Sounds good, Your Honor, thank you.
All right, good.
May it please the court, my name is John Scanlon. I'm here on behalf of the appellee Jeffrey Hubert today. I want to start by saying that there are a number of things that I think we agree on today, which is the fact that the totality of the circumstances in these cases must be considered, and I believe you will do that as part of your de novo review. Her Honor asked about the judge's order. I believe that if there's confusion in that order, that it stems from what I believe to be sort of a larger confusion between the terms willful, wanton, and reckless. Because in my experience, those terms are often used interchangeably. They all mean something more than negligence. They do all have their own unique legal definitions. I would wonder if you put all 3 of them in front of the jury, if they would find a certain conduct to satisfy one and not the other, and perhaps, that's my speculation, that trial court found that there were issues of fact surrounding Officer Taylor's conduct that met one or all 3 of those definitions. There's these cases, and this court is no stranger to these cases, immunity cases with police vehicles, although I remind the court this is not a police pursuit case. And although this probably would be considered to be an emergency call, although the Boston Heights in their reprimand called it a call for service, courts do routinely in these cases examine the details of the type of call. For example, this court in Cunningham v. Akron noted that there was a felony in progress, and therefore the officer needed to respond with all stealth and haste. That is not the case here. There's been no evidence ever provided by the village that there was a need for such urgency that you would run a red light while accelerating through a busy suburban intersection. Now, I think there are a number of factors here that create issues of fact with the village and Officer Taylor as they pertain to wanton, willful, or reckless. Number one, this issue of the siren. Now, I read appellant's brief, and there's mention of a siren all throughout it. There's a witness. And by the way, the affidavits that were discussed previously were affidavits produced by the village of Boston Heights and Officer Taylor. To the extent that they are deficient, that is an evidentiary problem that falls on them. I would question the credibility of the witness who says the sirens were activated, because finally at page 8 of the appellant's brief they acknowledge that he was not using his siren. He was chirping, which is not the same thing as a siren. The plaintiff testified that he heard a whoop. In my mind, that's very similar to a chirp. The important thing is, by the time the plaintiff heard this whoop, it was too late. He heard the whoop a split second before the crash. They were already on a collision course that could not be avoided.
Counsel, in terms of the whoop or the chirp or the intermittent siren sound, am I correct in reading that there was testimony, and not just from this officer, but a superior that said that they're advised, the officers are advised to do that as they approach intersections?
Your Honor, there was brief testimony that they are trained to chirp. I'm not aware of any details as to why or when.
If that's the case, the only thing I'm getting at is, wouldn't that go to diminish willfulness or wantonness?
Your Honor, if it were true, it might diminish whether or not he followed his the village protocol. I don't believe that the village protocol is dispositive of what might be reckless, or wanton.
You notice I didn't say reckless, I said
Okay.
willfulness or wantonness.
Okay, wantonness, yes, thank you. That is the standard for the village. I would remind you that the village also reprimanded Officer Taylor and used specific language in doing so. And their policy says, must sound the siren. Sound the siren to me. And I guess, since we're talking about the facts, the devil's always in the details in these cases. Mr. Huber, it's undisputed, was approaching this intersection from a different angle. There was no visibility between he and the officer, obviously, because they collided. So they couldn't see each other. But the affidavits are from witnesses who were on the same road or already stopped at this intersection. So, of course, they're going to visualize this car, this cruiser, or its lights. Mr. Huber did not have a luxury. The reason we have sirens are so that people can hear them, perhaps before they can actually see the cruiser. And that was the problem in this case. Mr. Huber wasn't in the same position as these other witnesses. And when we're talking about the other witnesses, the other vehicles that Officer Taylor knows were on the exit ramp, and one was at the intersection, that alone should have told him, this is a pretty busy intersection at this time of day. I need to stop. Now, we talked about the siren. The siren was not on. We believe that creates an issue of fact, but that's not it. He did accelerate through this intersection. And I believe that counsel stated that he was going through at 20 miles an hour. Well, he was actually, according to their experts, going at least 30 miles an hour. And if we question whether or not 30 miles an hour is a safe speed, all we have to do is look at the vehicles post-crash. This was a significant impact collision. And going from 20 to 30 in 2 seconds is a 50% acceleration. And not only that, but it's the most crucial 2 seconds that there are. Now, if Officer Taylor slows down from the speed that he was traveling on Route 8, and he was driving, the court has in the record these 3 dash cam clips, and I think they're significant, and I think they tell a lot more than any testimony, a year later. He was going excessive speed on State Route 8. You can hear his engine, you can hear the road. We don't hear any siren, we don't hear any chirping. The next clip is the split second before the crash. You can see the red light. You hear a revving engine. You don't hear any chirp or any siren. The first time we hear a siren is in the 3rd clip, and the testimony was that that's most likely because the siren, the overhead siren, automatically triggered when there was an impact. The video is gone because the dash cam is damaged. That siren is extremely loud in that 3rd clip, and had it been on previously in those other 2 clips, I believe we would have heard it. The time to slow down was at and going through the intersection, not back on the exit ramp. He did not have a clear visibility of all traffic approaching this intersection when he made a conscious decision to accelerate through the intersection on a red light. And everything that Officer Taylor did in this case was a conscious and deliberate decision. The decision to run a red light, deliberate, conscious decision, knowing it could cause harm. Accelerating through instead of at least slowing down to a much lesser speed or stopping for a matter of seconds. We talked already a little bit about the nature of this call. There was nothing about it that suggested he needed to operate his cruiser like that. And to the extent that immunity is their burden of proof, that was evidence that they should have brought in front of the court so that we could analyze that issue a little further. They did not.
Was the accident he was responding to in the same intersection?
No, Your Honor, it was another part of the village.
It was a different part of
The testimony was that there was a motor vehicle crash, no evidence of any injury, and that's what he was responding to.
Thank you.
So, to summarize, we have 3 different but similar legal standards, 2 of which would hold the village liable or remove immunity, and 1 would hold Officer Taylor. And Officer Taylor is not entitled to immunity if his conduct was reckless. And I think...
Can I ask you a question on
Yes.
that? Because opposing counsel used that word also, and I will admit to maybe just missing it, but I don't see the word reckless anywhere in the court's opinion.
In the court's
Other than
opinion...
the definition, I'm sorry, the court did define recklessness, but in the conclusion,
Your Honor, I would agree with you.
okay.
I would agree with you. When we talk about, if we had to take these terms and put a catchphrase, reckless conduct is a conscious disregard or indifference to a known or obvious risk. And I don't know, I think this is a classic case of a conscious disregard or indifference to not use that overhead, loud, continuous siren, to not slow down to a much slower speed, or at least stopping for a matter of seconds before going through this intersection. The nature of this call was such. It did not require this type of conduct. The visibility of that intersection wasn't good, especially for Mr. Hubert, who was not in the same position as the witnesses. And I believe at this time I will acquiesce to my fellow athlete.
All right, counsel. Looks like he left you 4 minutes and 13 seconds.
Thank you, Your Honor. And may it please the court, my name is Louis Malaturno. I represent State Farm Mutual Automobile Insurance Company today. Most of what I had to say has already been said, but I do want to touch on what I believe is a very important point. And one of the key points in the court's decision in this matter that was brought up by Judge Sutton, that is the reprimand from the city. There was also reference made to the citation that was issued by the State Highway Patrol. These are important factors in considering the court's decision in this matter. And the reason it is important is because we are talking about terms such as willfulness, we're talking about terms such as recklessness. Willfulness is defined as implying intent, but it's important to note that that intent is with regard to the action that is taken, not the outcome of the action. What was the action or inaction in this case? The evidence points to, and what creates an issue of material fact in this case, precluding summary judgment, is the action of Officer Taylor or inaction in failing to turn on his siren. Common sense dictates when entering an intersection, we're all familiar with Heinz Hill Road at Route 8. The sight lines to the right and left are not good.
Counsel, are you suggesting that is it your argument that it was specifically the failure to turn on the siren that changed this into, to meet the standard from negligence to recklessness or to wanton?
Yes, Your Honor.
Behavior? Is that?
It is, but it's not the only thing. But the point I would make is it's not the only thing. At issue here is whether or not the siren was turned on. There is strong evidence that the siren was not turned on. What is the importance of the siren? To give warning to people like Plaintiff Huber who are using the roadway that there's an emergency vehicle approaching, that you need to yield, that you need to comply with revised code 4511.45, which requires you to yield to an emergency vehicle that's using lights and sirens.
Can you speak to anything else that you believe pushes this case from negligence to recklessness?
I can, Your Honor. It's not just not using the siren, it's also approaching a red light. That's a factor in this case. It's consciously and knowingly entering the intersection under the red light. It's going down on the accelerator. The airbag control module indicates the accelerator 2 seconds before this accident is at 50%. This officer is accelerating into the intersection to go through the intersection, knowing that he's entering the intersection under a red light, knowing that his siren is not engaged. The reason there's so much discussion of the whoop and the chirp, there is a requirement that the whoop is used, but that's in addition to what's required by the revised code. He has to use his siren. That's why he was reprimanded. That's why the State Highway Patrol cited him.
Did the, I believe that counsel mentioned that the Highway Patrol officer revised his position on, in testimony, is that correct?
Yes, that is correct, but it would be interesting to know what the Highway Patrol trooper's testimony is going to be on the stand. We have two sources of information in this case. One is the GPS. It seems fairly clear that there was a malfunction in the GPS because looking at a photograph, a still that was taken from the camera that was on board the cruiser, it gives a GPS position of 000, both longitude and latitude. So clearly it's not receiving a signal. However, it also shows that the cruiser was moving at 60 miles per hour. Why the longitude and latitude would fall to 0 but the speed would still register as 60? The trooper doesn't know, we don't know, and frankly, the city doesn't know. Okay, but there is some evidence taken from the cruiser of 60 miles per hour. There are also two witnesses to this accident. One says about 30 miles per hour, another says 30 to 40 miles per hour. There's the testimony of Officer Huber, and more importantly, there's the information from the airbag control module. The airbag control module indicates a speed in excess of 30 miles per hour at the time of airbag deployment. But it also indicates that Officer Taylor was on the accelerator, that he was accelerating into the intersection. So all of these things have to be looked at in conjunction. And contrary to what's asserted by the appellant, it's not just one thing. It's several things. The most important thing we would say constitutes willful misconduct is a choice that was made by Officer Taylor. And that choice was not to utilize his siren. Why he didn't utilize his siren is a mystery. But the issue for this court is not whether or not Officer Taylor acted willfully, wantonly, or recklessly. It's whether or not there is evidence. There's an issue of fact to submit to a jury. And I would submit to you the trial court got it right. She didn't center on just one thing. The judge was very clear that non-use of that siren was a choice. It implies intent. It can be construed by reasonable minds to constitute willful conduct. It can be construed by reasonable minds to constitute reckless conduct. And she's going to defer to the jury on that issue. So,
Counsel, how do you address then the woman who pulled over who heard the siren.
That's why we have an issue of fact. We have witnesses who say one thing and witnesses who say another. We have a plaintiff who says, all I heard was a whoop at the time of impact. That's not going to do him any good in terms of knowing that there's an emergency vehicle approaching. I mean, frankly, Plaintiff Huber was never given a chance, and that was because of the willful misconduct of Officer Taylor. So that goes precisely, Your Honor, to why there's an issue of fact in this case. We have witnesses saying different things. We also have two sources of information for the cruiser that say different things. Ultimately, these are issues to submit to the jury. And it's our position the trial court got that right. She says very specifically in her opinion, we have testimony going both ways, and that's where my inquiry ends. Because she's not going to decide which witness is right and which is wrong.
But is it where her inquiry ends?
We believe it is.
But you started your argument with totality of the circumstances, or at least your co-counsel did. Everybody did. I think everybody agrees it's totality of the circumstances.
We are looking at the totality of the circumstances, but looking at the totality, there are issues of fact. There's disagreement among the witnesses as to exactly what happened here and what the conduct
I
was.
think what Judge Gallion is saying, I don't think the opinion addresses that the officer admitted entering the intersection on a red light, that he never stopped, didn't address any of the speed factors that you're arguing. It seems to have stopped after the siren.
Well, but the use of the siren, we think, is the main point for the court
Yeah,
to
in and of
address.
itself.
And there, in and of itself, and there's an issue of fact with regard to that. My only point is that there are other factors that a jury can look at, and hearing the instructions on willfulness, wantonness, and frankly on recklessness, can't conclude that Officer Taylor met those standards, because there was willful misconduct in this case.
You know what? I appreciate your argument. You were way over time.
That's my
It was
apologies.
such an interesting
Sorry.
argument. But thank you for your argument. And I apologize, because I'll give you a few, maybe an extra minute for rebuttal, since I let them go 3 minutes over.
Thank
How's
you.
that sound?
I appreciate it.
All right, go ahead.
I wanted to address one of the first things that they indicated that the need for urgency was lacking. You know, the police officer, it's clear from the record, was responding to a dispatch that there had been a motor vehicle accident. And in this particular case, I mean, you know, you think of circumstances where the facts of the accident are known or unknown. In this case, they were unknown to the officer who was dispatched. And he followed departmental policy, which, if you don't know whether there's been an injury, you're to presume that it's an injury accident, which then requires a more immediate response. So that was, the urgency was because of the unknown nature of the accident. Secondly, regarding, I think they mentioned excessive speed on State Route 8, that's irrelevant. How fast the vehicle was traveling on Route 8 has nothing to do with the speed in the intersection, which is really the issue in this case, what happened in the intersection in those few seconds. They had made a reference to the fact of the reprimand. Police officers are reprimanded for accidents when they damage departmental property, I mean, when they're negligent. And that's certainly, I mean, I don't think Officer Taylor would dispute that he was negligent in this case. One of the things that counsel just mentioned is that there's some question or debate over the speed. Neither State Farm nor the plaintiff had any expert testimony to dispute what was on the event data recorder, the black box, as to his speed. And the expert testimony from Rick Stanford, taken from that black box testimony, indicates that his speed was 20 to 20.9 miles an hour as he entered the intersection, and he accelerated to 30 to 31 miles per hour. So, and their repeated reference to the 50% increase seemed to be that they believe that as well, because 20 to 30 is an increase of 50%. But certainly, they've offered no testimony contrary.
Could that also indicate whether or not he applied his brakes at the intersection? Is that
You know, something, my recollection was that the brakes weren't applied until impact, or not before. Because keep in mind, neither saw the other. And that's actually the point that I wanted to conclude with. You know, it seems to me that this is a classic negligence case. On the one hand, you have the driver failing to yield the right of way to an emergency vehicle because he didn't see. On the other hand, you have the officer proceeding through the intersection after slowing down to 21 miles an hour, proceed to go speed up a little bit so that he could get through the intersection, and he didn't see the driver either. It seems to me that it's a classic negligence case. Neither one saw the other. As to the last point I want to talk about was, you're right, the court only focused in its opinion on whether it was an issue on willful or wanton conduct and doesn't really do the reckless analysis. The opinion is bereft of that. So, however, you know, I believe that the court, in conducting a de novo review, is permitted to act as if it was the court of first review, so I'm reviewing the case. So, I don't know that the court's failure to address the recklessness it makes you unable to decide the issue of the case. In any event, as we indicated from the outset, applying these rigorous standards that are in most cases difficult to establish, that's true of this case. And we would ask that you reverse the trial court and find in favor of both the Village of Blossom Heights and Officer Taylor and grant them immunity. Thank you very much.
All right, thank you both for very good arguments. Very interesting case. So what we're going to do is take the matter under advisement. Court will issue a decision in due course. Each of you will receive a copy of the court's decision as soon as it is released. You can also keep an eye out on the court website where the opinions are posted. The next scheduled date for